Please be seated. We're ready to hear argument in 24-0081 in re Carlson.
May it please the court, Mr. Sullivan will present argument for the relators. Relators have reserved 5 minutes for rebuttal.
Good morning, Mr. Chief Justice. May it please the court. John Sullivan on behalf of the relators. The court should grant the writ here because the Comptroller failed to sign the order required by law. Thus, there's no final agency determination as required under the APA. It's uncontested that under Section 2001.141, agency finality is required in order for a party to seek rehearing and ultimately judicial review. It's also uncontested that the agency must sign the order or decision to make it final. Now, there are 3 things here that show why the ALJ's order in this case is not final. First, as SOA's general counsel confirmed, SOA has no authority to issue the final order here. Second, the rules allow for the Comptroller to modify the ALJ's order. That could not be the case if the ALJ's order was already final for purposes of disposing of the contested case. Third, we know that this is not a final and appealable order because it lacks the findings of fact and conclusions of law specifically stated as required by .141b. Now first, the law is that SOA doesn't have general power to sign final orders. SOA has no authority to issue the final disposition of any case that it gets on behalf of any agency, except in limited circumstances of occupational licensing where the agency has specifically asked SOA to take on that role. SOA doesn't have the authority for that final disposition because it comes from the agency with whom the contested case is filed. This is precisely, again, why the General Counsel for SOA informed relators 20 days after the order was signed that the order here was not final and appealable. Now,
Is that enough to resolve this case? I mean, under Mosley versus Texas Health and Human Services Commission, when the government misrepresents something to you about, what the procedure is supposed to be, and you rely on that, you're entitled to rely on that.
I would welcome a win in any fashion, Your Honor, but I think that's right. But just also the General Counsel wasn't wrong about that either, right? Like SOA's General Counsel understood and is representing the agency's position on this question. I think, which is why the Comptroller didn't respond to our arguments about an agency position deserving deference with respect to the interpretation of the statute. And the Comptroller here didn't delegate any of its contested case final authority to SOA, right? It was only given to SOA for the normal hearing process that takes place under a SOA hearing.
Do you need this court's Texas citizens kind of not totally maybe warm embrace of the now dead Chevron doctrine? Do you need that to win this case, counsel?
No, we do not, Your Honor. But again, you look at the email from SOA's General Counsel where he said, quote, all cases referred by the Comptroller are PFD cases. So this case goes back to the CPA. What that means, all cases referred by the Comptroller are proposal for decision cases. The Comptroller isn't one of the agencies that gives or asks SOA to make final determinations for it. Everything that they give to SOA is a proposal for decision case. That's from SOA's General Counsel. So now, once the findings of fact and conclusions of law are set forth and adopted by the agency, against whom the contested case is brought, then you can seek rehearing, then you can seek appeal. We see that under Section 2001. We see that under the PRPA, the underlying statute here that relators will bring their case under. Your right of appeal is always against the agency against whom you're bringing the contested case. The only time you take rehearing against SOA is in those specific instances of occupational licensing where the agency has asked them to take on the role of being a final decider. And that doesn't happen here. Second, we see that the agency against whom the contested case was brought here, the Comptroller, retains the authority to modify or adopt the SOA order or decision. That's under section 2001.058C. Now, if a jurisdictional order by a SOA ALJ were able to finally dispose of a case, there would be no way that the Comptroller could adopt or modify that opinion. The party who brought the case would be left trying to seek rehearing against SOA. Again, when we reached out to SOA on that exact question, they said, no, you can't bring rehearing here. It would be against the Comptroller. This can also be seen in the Comptroller decisions that we cited in our reply brief, where the Comptroller got a jurisdictional ruling from SOA and then in one instance modified it, and in one instance just adopted it, and then issued a final Comptroller decision or Comptroller order. If you pull that up on Westlaw, you can see it, that actual case, issued a final Comptroller order that set forth findings of fact. It set forth conclusions of law, and it either in one case adopted and in one case modified that jurisdictional decision that came from SOA. Okay? The third reason, again, the agency resolving the contested case and making it final for purposes of rehearing and appeal must, according to point 141B, set forth findings of fact and conclusions of law. The order here is missing those. And the statute says that they must be, quote, separately stated. They have to be enumerated, just like the Comptroller did in the examples that we've provided to the court. The Comptroller cut and pasted the SOA ALJ's order and then said, we're going to adopt it or modify it, and specifically listed those findings of fact and conclusions of law. Set it forward just as the statute requires. So even if SOA had authority to issue final appealable decisions in every contested case, which it doesn't, the ALJ's order here still doesn't meet the statutory requirements for finality. And you can look at those examples that we've given you.
The letter that came in on Monday from your friend on the other side challenging your standing on the basis of the logic of the El Paso Court of Appeals, do you have anything you'd like to share with us on that?
Yeah, thank you, Your Honor. I would say 3 points. One is that the Green case, it's wrong. Second,
If it's right, is it indistinguishable?
it's not, Your Honor. Second, it's distinguishable because relators here are seeking a different remedy under the PRPA. And third, it kind of begs the question, right? We're here trying to get a judicial review concerning facts related to jurisdictional findings. We're trying to get a court to actually examine what the ALJ first looked at this and said, oh, this is disputed fact. And then the Comptroller came back and said, no, I really want you to look at this again. And the ALJ changed his mind and said, okay, all right, I'll look. And we need a court to consider that. And you're begging the question just to say that, there's no jurisdiction because those facts haven't been reviewed yet. And so that's why this case is just about the narrow question of what constitutes finality with respect to that ALJ order.
Did the ALJ dismiss here solely on the basis of limitations?
That's correct, Your Honor.
Okay, and was that jurisdictional?
It was jurisdictional for purposes of this statute, yes, because it's you're seeking to waive governmental immunity.
So does 155-503 apply? 155-503D, then they argue because it was jurisdictional, 155-503D applies and permitted the ALJ to dismiss as a final order for lack of jurisdiction.
So there's a difference between issuing an order, which ALJs are allowed to do, and issuing something that becomes final for purposes of disposing of the contested case. Now, if you go to 503 D1A and you look at that, you can see that and I think we have it here at tab 12 for you. on the second page, it says, the judge may dismiss a case or portion of the case from SOA's docket. Right? So that doesn't mean it's disposing of the entire contested case, because contested cases go through the agencies, right? So it's dismissing it from SOA's docket. And then if you look at A, it also says lack of jurisdiction over the matter by the referring agency. So this is in those cases where, you know,
So in other words, it's your position that, it's not your position that 155-503B does not apply here. It's your position that even when 155-503 applies, what the ALJ issues that dismisses a case or a portion of the case is still merely a PFD that has to then be finalized by the agency itself.
I would agree with almost 100%. I would just say that looking at the end of that part A there, it says by the referring agency. I'm not even sure if this applies in this case, because this wasn't a challenge to the jurisdiction of the referring agency. Right. This was a challenge to the jurisdiction of whether or not the statute of limitations was met. So I'm not even sure that 155 applies, but if it does, then the rest of your analysis is exactly correct. That it doesn't somehow transform the SOA's power into the power to finally dispose of contested cases. That's not what 155 is doing, and it couldn't, right, and still line up with the rest of the statutory scheme.
So even if it was clear that in some other case, the SOA judge, the ALJ, dismissed because he or she found that the referring agency had no jurisdiction over the matter, it would be your position that that decision still requires a final order from the referring agency agreeing.
Yes, that's correct, Your Honor. And so, again, here, you can look at the examples that we provided the court where the SOA ALJ said, I'm making this determination based on jurisdiction, right? And by the way, this 155-503 D1A was in effect as of 2008, right? And the decisions that we provided you were from, we've just found a couple of examples because they dealt with the comptroller addressing this question of jurisdiction and responding to a SOA judge saying that there was no jurisdiction. So those were in 2011 and 2013. So after the statute was written, the comptroller was looking at SOA determinations regarding jurisdiction under this statute and was saying, okay, I'm going to set that forth and I'm either going to adopt it or I'm going to modify it. And then I'm going to provide findings of fact and conclusions of law and then sign it at the end. Susan Combs, former comptroller. Right, because that's what's required.
It seems to me that drawing a distinction between jurisdictional dismissals and non-jurisdictional dispositions is potentially difficult, just given that line is not always clear, particularly in cases against the government.
I think that's right, Your Honor. And then if you kind of go back to and you're looking at this 141A statute, right? The comptroller's expanded reading of all this in this case kind of creates this anomaly where you have under the statute you're trying to figure out who is the agency for purposes of finality, and you say, well, okay, if the comptroller loses, then the comptroller is the adverse agency, right? Because it's going to have to go back to the comptroller for a signature.
Counsel, so that's the question that I have. So Mr. Justice Busby threw you a lifeline, and you gave the Al Davis just win baby response. And I'll ask the same for your friends in opposition, able counsel from OSG. Can you just hum a few bars for me, because Section 22.002C of the Government Code has some limitations on executive officers. If the Mosley versus HHSC lifeline is going to work for you, can you just tell me what would you be going to a district court to do to try to win that way? And who exactly would the district court be telling to do what?
Well,
would they be telling SOA? Would they be telling the comptroller?
So that's kind of what that's unclear, Your Honor. Under that the reading that the comptroller is trying to advance in this case. Normally, if you're going to bring a rehearing motion, you bring it against the agency, right, against whom the contested case was filed. But here, we would be asking to go against what the SOA General Counsel said and said, no, you're wrong, SOA General Counsel. We relied on that. I think that's what Justice Busby was saying, we relied on what you're saying, and the, Supreme Court of Texas has said that you were wrong, so we have to come back and file this here now. Except that then that goes against the other statutes, 171 and 146, that say you don't bring your rehearing motion against SOA, you bring it against the agency.
Yeah, I think one of your brethren earlier this week in a different cause closed with the phrase Kafkaesque nonsense, and so I'm just trying to see if this potential lifeline is actually one for you. But I don't want to.
I think we would find a way to make it work, and everyone have to listen to what this court said, of course.
Any further questions? Thank you, Mr. Sullivan. We'll hear from the respondent.
May it please the court, Mr. Scanlon will present argument for the respondent.
Mr. Chief Justice, and may it please the court. The Carlsons are asking this court to parse the words in an email message from a lawyer with no authority over these proceedings, rather than looking to the plain language in the relevant statutes and rules that direct the outcome. The court should deny the petition for writ of mandamus because it is the ALJ and not the Comptroller who issues the final order of dismissal in a case where subject matter jurisdiction is lacking. Further, the Carlsons' failure to timely avail themselves of their available administrative and appellate remedies does not entitle them to issuance of the writ.
What's your best purely statutory argument for what you just said, setting aside the administrative code?
Yes, Mr. Chief Justice. So this case is being brought under the private real estate
Private Real Property Rights Preservation Act.
Thank you, Justice Sullivan. I'll just refer to that as the act for simplicity's sake. That statute is unique because it gives a litigant the election to go straight to a district court and bring their takings claim or to bring a contested case. Now, an agency's enabling statute will dictate result there in terms of what are the contested case procedures that should apply. But the Comptroller here has no authority to promulgate rules under the Act. The Comptroller is responsible for litigating tax matters mostly, and those are handled under the Government Code, Section 2003.101. Now, in the absence of rules, and there actually are rules that the Comptroller has promulgated saying that we handle contested cases in tax matters under the Comptroller's rules, and when those rules do not apply to non-tax matters, then the SOA rules of procedure apply. And that is how you get to Title I of the Texas Administrative Code, Section 155503D1, which allows dismissal of a case for lack of subject matter jurisdiction by the referring agency and does not require remand to the agency.
So I'm not necessarily suggesting that your argument is invalid on this basis, but in response to my question, I'm not hearing a statutory argument. I'm hearing a sort of immediate resort to the administrative rules. Am I understanding you correctly?
Not exactly, Mr. Chief Justice. So the APA allows SOA to issue orders and decisions. It's more clear on what a decision is because of the proposal for decision process that's set out, but the word order is governed by the SOA rules. The SOA rules under this court's precedent are given the force of statute. And the statutory kind of basis for following 155503D1A is that those rules in that provision and in another provision set forth dismissals for default and for dismissal for want of prosecution. Default requires remand back to the agency under those rules, so does a DWOP. There is not similar language under the rule governing dismissals for lack of jurisdiction.
The Chief Justice's question is vital to the rule of law in this state. It can't be turtles all the way down. Our oath is the Constitution and laws of this state, not the things that our friends in the executive branch wrote up for administrative convenience. And so can our friends in the executive branch make a rock so heavy that our friends in the executive branch can't lift it? Or if something was done wrong here and they're getting sent from one hallway to another to say, no, you've got to go to SOA, no, actually, you need to go to the Comptroller. You know, every time we're seeing, you know, Chapter 155 of the Texas Administrative Code, I can't speak for the Chief Justice, but I'm looking for some law here. And so just which statute do I need to look at closely to say the force of law that backs this, you know, sorry, the moose out front should have told you thing, gets you the win here?
Yes, Justice Sullivan. So the Chapter 2001 of the Government Code, the Administrative Procedure Act, establishes the minimum procedures that have to apply here. The definition of decision and order, as my friend on the other side cited to 2001-041, if it's in a writing, it's signed by a person authorized by the agency to render the final order, then it can become a final order. The Carlsons didn't timely seek a rehearing from that order, and they have not identified really any provision in the APA that dictates, or the Act that dictates a different result. So this, again, this is an unusual case because it's not your particular, your typical contested case in which an agency is charged with administering contested cases under a statute. It is simply the litigant can go and file a contested case and claim a takings. The Comptroller does not have rules that govern that procedure. So,
assuming the authoritative nature of the regulation 155-503, Relators Counsel argues first that 503 D1A doesn't apply because it addresses dismissal for lack of jurisdiction over the matter by the referring agency. Do we have to ignore that language to agree with you here?
no, Justice Boyd. I think that by the referring agency can also apply in the defensive posture that we find ourselves in which we are pleading statute of limitations as a defense. So
So you think the statute of limitations deprives the Comptroller of jurisdiction?
In this case, yes, because of the defensive posture that we find ourselves in. And I'd add that
We're frequently arguing amongst ourselves, and counsel are debating whether something's jurisdictional or not. Right? That's a question that often comes up. It comes up in the sovereign immunity context. It comes up, all the time, and the answer is not always clear. And so if you're right, and there's this distinction between jurisdictional dismissals and non-jurisdictional dismissals, and the answer to that question determines, whether somebody has correctly appealed or has lost their rights. It seems to me that's a weak limb to put a heavy weight on.
I understand the concern, and if there had been a motion for rehearing in this case, that could have been maybe more hashed out. We have not contested the fact that there are not findings of fact and conclusions of law that were in this order. The problem for the Carlsons is that they did not timely raise that defect under SOA's rules to say that, this is supposed to include findings of fact, conclusions of law, and there is case law that says that doesn't prevent the order from becoming final.
Well, leaving that aside, so it is the fact that it's a final order, and you recognize the distinction between orders and decisions. But a decision isn't an order determining jurisdiction a decision, as opposed to a DWOP or default judgment. It actually has a consideration of jurisdiction by the court on that issue, and it's a decision, even though it's a dismissal.
If I understand your question right, could this be looked at as a decision rather than an
Right,
order.
that the comptroller can modify, change, and, has the final authority over.
The comptroller, under the comptroller's rules and under the SOA rules, wouldn't be following their own rules if they did that, if this was an order. If it was a decision, then, which we're not conceding that it was,
It's a final determination.
right, and a decision, as contemplated under the Administrative Procedures Act, means that it's a decision on the merits, that whoever's adjudicating it, whether SOA has the final decisional authority under a statute or it has to go back to the agency, they've decided there is jurisdiction. They're going to the merits of the case, they're weighing the evidence, and that is normally, in the mind run of cases, something that is left to the expertise of the agency to finalize.
Well, limitations does go to the merits. It's just that because it happens to involve an agency, it also goes to it. The result of you prevailing on limitations is that there's no jurisdiction. So it seems like it's both.
I think I would disagree. I think there's a difference between having an ALJ determine what the jurisdictional facts are and reaching the merits of a case where they're having to weigh the evidence and apply their expertise to sort of see what's the outcome, assuming that there is jurisdiction. And
So if we agree with you on that, Relators Counsel's second argument is, well, even if D1A applies and this involves a dismissal for lack of jurisdiction, D1 itself only addresses dismissal for lack of jurisdiction or lack of jurisdiction requiring dismissal from SOA's docket, which just means, okay, comptroller refers it to SOA for a PFD, and SOA looks at it and says, the comptroller doesn't have jurisdiction, so we're going to dismiss it, but the dismissal is only from SOA's docket. Comptroller still has to dismiss it. What's your response to that argument?
there's nothing in the governing statutes that actually say that. The statutory authority that...
Well, you're relying on a regulation here that says lots of things. The statute that authorizes the rulemaking that resulted in the regulation, the statutes don't say.
Well,
So what with regard to what are you saying the regulation is wrong or unauthorized or contrary to statute?
no, Justice Boyd. I think what I was meaning to say under the APA, which we have to follow for minimum procedures, 2001-041 says that an order can be final when it is in writing and signed by a person authorized by the state agency. The state agency can include SOA when it is determining contested cases. And
So do you acknowledge a difference between an ALJ decision and an ALJ proposal for decision?
yes, Your Honor.
And here, is it your position that this involves only a decision, that when the referral was made, it was made for a decision as opposed to a proposal?
I think no, Justice Boyd, the referral is only for SOA to determine the contested case. That could result in a PFD. It did not here, unless you follow the General Counsel's position, and I want to address that.
Could I ask you a quick question about that? I can't seem to find the identity of parties in counsel section in your brief, but it's probably my IT incompetence. Is OSG representing only the Comptroller's office here, or is OSG also representing SOA here?
We only represent Comptroller in this proceeding. So I guess to get back to your question...
Do we need a CVSG for SOA's views?
I don't think so, Mr. Chief Justice.
Should we gather that the state has sort of conferred on this and that you're representing the state of Texas's position on this, or do we need to be concerned that we're not getting the full position of the executive branch of the state of Texas?
And I'm with the Chief Justice on this. The reason that I ask is same question that I had for your friend in opposition. I'm going to ask you, Mr. Justice Busby asked about this Mosley against HHSC lifeline, or maybe it isn't. And I'd like to know your views on how that's going to work and where SOA fits in on it. And so but I don't want to ask you to speak, for or against SOA if they are or aren't your client currently.
Well, I think that SOA in this context kind of stands in the shoes of the comptroller when a case is referred to them for adjudication. So I am not authorized to represent the definitive position of SOA right now, but for the comptroller, Mosley doesn't apply here. Because the Carlsons are not accusing the SOA General Counsel of misleading them. They're saying he gave them the right view on the law, and they have stood behind that view on the law. And they relied on it to say that this was a proposal for decision. By the way, the order doesn't say anything about it being a proposal for decision or give any instructions to the referring agency as to how to follow up on it. So
It's you that's saying the general counsel was incorrect.
I think that the general counsel's email that contains a, let's call it an informal opinion, created a conflict with SOA's own rules. Because they basically said that it's always, the comptroller always has PFD decisions. And that view might be right if you're in 2003-101 where the comptroller is adjudicating tax cases and will always have the final decisional authority. But that's not the correct view. It didn't appreciate this claim under the Act where we're in a defensive posture. We're not adjudicating a tax matter.
Well, I mean, Attorney General Paxton is the chief lawyer for the state of Texas. And so if maybe it's an intramural dispute and it's been resolved, but what I'm hearing is that maybe it hasn't been. That is, whether SOA was right or wrong, whether SOA is the same or different than the comptroller. But if we are going to be sending people down different, hallways within the Kafkaesque nonsense or whatever, and SOA is going to be maybe on the receiving end of some kind of Mosley thing in the district court, and that does matter because a district court wouldn't have the same authority if it's the comptroller's office versus SOA. And so that's kind of what I'm struggling with here. And just to diagram this, I would need a whiteboard. And so
Sure. Well, if this court agrees with our position, there's no need to reach the Mosley issue because there's not a due process claim that the Carlsons' due process rights were violated, and therefore it has to be sent back. We also made the point in our brief that it would be futile to do so because of the limitations issue that was clearly established in SOA. But I want to, with the remaining time I have left, kind of turn to standing unless I've left any questions on the table that I'm not aware of.
So just before you do that, and I completely understand if this is not an issue that you've thought through prior to the argument, but the Constitution does say that the Attorney General represents the state in this court in particular. And so I think we need some clarity in a follow-up letter from the Attorney General's office about the state's position, rather than there being this ambiguity about what the comptroller thinks and so is saying something else. And
Yes, Mr. Chief Justice. I'd also just add that to the extent the order was defective, there was an opportunity to file a motion for rehearing, or if it was a PFD, to file exceptions to the PFD in SOA. They did neither of those things, and we would.
They requested that the comptroller rule.
What's that?
Didn't they request that the comptroller rule?
By the time they made that request, Justice Bland, their time to file an MFR had already run. So the statement.
Time to file an MFR, but if the ultimate decisional authority is the comptroller hasn't acted, is a request sufficient to preserve that?
We would say no here, Your Honor. They were required to file the MFR. MFRs under the APA can be filed in response to orders and decisions under the plain language of it. I hope I've kind of answered your question there.
I mean, if somebody wants to stand on the papers and just proceed expeditiously to district court, and they think the next step is to get an order from the comptroller, and then they can get to district court, why is filing a motion for a hearing necessary?
Well, they either had to correct the defects in the PFD or file a motion for rehearing from the order, because there were no findings of fact or conclusions of law for the comptroller to confirm. When they waited too long to do either of those things, they had a procedural default and it would have been barred.
The comptroller can't modify the decision absent findings of fact.
It's not, we would say it's not a decision under the APA, it's an order, and the comptroller would
Can't
not
modify the order.
be following the comptroller's own rules if they did that. As far as standing, we would assert that the Carlsons are in the same posture essentially as the landowners in the Green case, and they have the same standing problems. The Carlsons have to satisfy injury, traceability, and redressability as to the comptroller, but as alleged, the Carlsons' injury to their property is not caused by the comptroller's certificate of limitations to Baird ISD. The Board of Trustees had to vote, they had to negotiate with the applicant had to actually construct a wind farm, and none of those things are fairly traceable to the comptroller, in the sense that the comptroller's certificate of limitation did not cause the board to approve it or the wind farm to be constructed. And it involves a third-party action here that this court has said is not enough to create standing under grassroots leadership. If there are no more questions, we would ask that the court deny the petition for writ of mandamus.
Any further questions? Thank you, Mr. Scanlon. Mr. Sullivan, you have 5 minutes.
So it seems like there's a really straightforward way to dispose of this case based on a concession just made by my friend. Right? He said, we have not contested that there were not findings of fact and conclusions of law in this order. They have not contested. That's true. There were not findings of fact and conclusions of law in this order. If you go to tab 4, that's section 2001.141, look at B. It says a decision or order that may become final under section 2001.144 must include findings of fact and conclusions of law separately stated. Must include. Therefore, he's conceded that they did not meet this step for finality that is laid out in the statute. Therefore, the order was not final. It was never final. Therefore, we couldn't seek rehearing, right? I mean, his argument over and over is that we should have sought rehearing. Well, Justice Sullivan has figured out, right? Like, where are you going to go to seek that rehearing? If we go to SOA and we ask them within our 25-day timeline, hey, what's the deal here? We need to seek rehearing, and they won't let us do it there, then I don't know where we're supposed to go. But it doesn't matter, right? Because the only question here is, was there finality? There wasn't finality. This is still an open, contested case. As we stand here today, this is
Pending in SOA or before the comptroller?
we believe that the ball is back in the comptroller's court.
Not if there's not a final order from the ALJ.
The ALJ isn't authorized to give final orders, right? The ALJ, that's why the findings of fact and conclusions of law have to be listed by the agency. And so again, I just ask you to take a look at those decisions that we referred you to in our reply brief, where the comptroller received a similar, or now, to be sure, the ALJ added some confusion here because he said final order at the top, right? But that doesn't make it so, just because he said that it was, okay? So
The answer can't be David Burns, I'll tell you later, right? Like
Right.
Which agency you should have gone to 20 days ago or something.
that's right, that's right. So we had to take that based on what the authority of SOA is. SOA's authority is set, their powers are set out in section 2003.042. And what you won't find there is the final disposition authority for a contested case, whether that be through a decision or an order. You won't find it there because it doesn't exist, right? And section 2007, I'll refer you, my friend mentioned that, the PRPRPA tells us what to do here. It says in .022, you can file a contested case. You can go to district court on a separate issue, but on the issue that we're here, you have to go to the agency. And then set .025 of that same statute tells you how to appeal. And it says you appeal against the agency that you brought the contested case against. That's the adverse agency. You don't you don't exhaust your remedies and then bring an appeal against SOA. You bring it against the agency. That's why you need a final decision from the agency. Okay. If there are no further questions, thank you.
Any further questions? Thank you, Mr. Sullivan. Thank you to all counsel. This concludes the arguments in the cases set for today. This case is submitted, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.
More cases to cross swords on it.